Good afternoon and welcome to yet another one of our exciting webcasts for today. I'm joined today by Reece Kingston, Senior Associate in our Sydney Workplace team. Reece, how are you going?
Good, thank you, Les.
That's excellent. My name's Lewis Izzo. I'm the Managing Director of the Sydney Workplace team at Australian Business Lawyers and Advisors. And we're here, Reece, today to talk about workplace investigations, the most common mistakes made. We've had a very high response rate today in terms of registered participants or viewers. I'm not sure if that's because there's a lot of people who are making mistakes out there who want to see how they can do things better, or there's obviously more seriously just a lot of interest in this topic because people understand, I think more and more, that when you're dealing with conduct, sometimes performance, but generally conduct or other issues in the workplace that are serious, that require some kind of fact-finding exercise, that people are getting more and more conscious of the fact that there's a right way to do things to get to the proper outcome, and that there's things you can fumble along the way that kind of cause a whole heap of issues, both legal and just practical issues in terms of getting the wrong outcome. So we're very excited to talk to you today about all the different kind of features of workplace investigations, how you can try and optimise them to do them as best you can and optimise the outcome for your particular business or organisation. We've got a fair bit that we're going to cover today. I won't rattle off the list, but you'll see up on your slide there the variety of topics that we're going to take you through. And we've also got with us today the iPad, so you can send through your live questions, and that way we'll see them in real time and can provide you with some responses. I've also got my own iPad here because we're going to take you, if we have time, to some case law examples, and I might read you out some of the facts of some of the cases to show you where sometimes things have gone off the rails. So hopefully it's going to be quite an interesting webcast. It's got a whole heap of different concepts for you all to kind of take notes down and consider what you should be doing in your own business or organisation. And so without much further ado, we'll probably get started.
Let's go.
So the first question, which I'm not sure if it's a common mistake or not, but it's something you need to consider up front, is whether you should be investigating. Why are you investigating? Does it need to happen? And that's a decision point at the beginning of any fact-finding process that really needs to determine then what kind of investigations you're going to undertake, why you're doing it, etc. So that's the first question you need to ask yourself. And I think the biggest thing about that is to understand what an investigation is. An investigation is a fact-finding exercise. It's about trying to determine what happened. So at a very preliminary level, one, if you know what happened, and it's a relatively minor issue, you're obviously not necessarily going to run through an entire investigation process. Where we typically see investigations run is where there's either something very serious, there's something factually complicated, there's differing versions of events, so something hasn't been admitted to. That's when you might investigate. And indeed, even if something's serious, if it's admitted to by a particular person, you might not be conducting an investigation because there's no facts to find. An investigation's all about fact finding. And so what you need to kind of do at the beginning of any disciplinary process, and issues happened in your business which might warrant some type of business response, is to try and work out, do I have a contested or muddled or unclear factual scenario? And if the answer to that is yes, then at that point, what you start to think about is, well, I need to do either a formal or informal process to try and work out what happened. And the question about whether it's formal or informal, we might come to in a moment, but at the very least, if we're talking about investigating, it's because factually something's unclear. And the first place or area where sometimes people might go awry is they assume a particular scenario to be correct, they discipline or respond as an organisation to a particular scenario when it may be the case that scenario was in contest or wasn't entirely clear. And if you haven't done the fact finding to begin with, then later on someone can impugn your disciplinary process or challenge the validity because you didn't actually have a transparent or sound fact-finding exercise to work out what happened. And I think that's the first thing. More often than not, employers do kind of get this right, that they do understand when they should be thinking about this type of exercise, but it's the preliminary issue you need to have a kind of consciousness of. Otherwise, everything else is going to fall by the wayside. So that's the first thing. And then I suppose that then does move us into the next question, which is, well, if I'm going to do an investigation, how am I going to go about it? Who's going to do it? Is it the right person? And a whole range of questions come up with this type of issue in terms of identifying who's going to do the investigation. I think what I've witnessed in many years of practice dealing with clients that are looking into disciplinary processes or some instance of misconduct is that probably the very first thing is capacity in terms of just the time and the resources to do something. Lots of businesses are very busy. Lots of individuals within businesses have workloads that are already relatively stretched. If someone's going to take on the investigation, they need to have the bandwidth to do it. Obviously, they need to have the confidence and capability as well. But if they don't actually have the time to devote to an investigation, you already kind of got a bit of an issue. I think the next thing you need to think about is independence. That doesn't mean you need someone outside of the organisation, but what you do need is someone who can be impartial. So if you've got a relatively large workforce, HR is a really good starting point, but HR might not be impartial in some circumstances. The individual within HR might be very closely connected to an investigation participant. On the other hand, if the investigation is into the conduct of a very senior person in an organisation, again, HR might not have the capacity to appear truly independent. And that's when all of a sudden we start to talk about things like optics, independence, transparency, and you need to ensure that the person who's going to do the investigation, people can have confidence in that they are doing this from an independent perspective. And so whilst external providers, whether it's law firms or other investigation providers, is an obvious source of independence, there are others too. It could be a board member. It could be the CEO. It could be a senior executive in a related company of the business. There's lots of people you might leverage off, but it's very important that from the perspective of the complainant and the respondent, they're able to have some reasonable faith that the person has a level of impartiality about them. And so really, before we do anything, you need to understand, do I have this kind of factually muddled scenario I need a fact-finding exercise for? And if I do, have I got the right person to do it? Now, before I'm going to hand over Reece to talk about some of the specifics of the investigation process, the last thing that is important to also consider is legal professional privilege. If you are looking into a matter that might give rise to legal liability, it could be a serious safety incident, it could be a serious sexual harassment matter, it might be that you want to have the veil of legal professional privilege as an extra layer of confidentiality or protection over the matters, the findings and the conduct of the participants of the investigation, so as to try and prevent documents or other correspondence coming out in court at a later date. If that's the case, you need to think about, well, am I going to engage a lawyer to do it? And is the purpose for this investigation becomes not necessarily just fact-finding, but fact-finding to obtain legal advice. And it's only if you are doing this exercise to obtain legal advice, that you can get that extra protection of legal professional privilege. And that's something you need to think about at the very beginning, because you can't change the purpose of the investigation once it's started. It's been commissioned for a particular reason. And so you need to ensure you've tied up all those bows at the beginning of the process if you are interested in securing legal professional privilege over the findings of the report, the communications exchanged within it. And that's something you have to grapple with at the beginning as well. Reece, we're going to jump straight into one of the most important things, I think, the allegations. So I'm going to hand over to Reece and we'll take it from there.
That's right. So we've called this the golden rule because it really is one of the most important things to get right. If you mess up here and you try and rely on the investigation at a later stage, you're going to be in a world of hurt. And as Lewis said, what we're talking about is allegations, and it's making sure that your allegations are clear and that your allegations have been put to the respondent. Essentially, if there's something factual that you want to rely on, what does the respondent have to say about it? You need to make sure they've been given their opportunity to provide feedback. What we say is to do your homework first. What we mean by that is make sure at the very start of the process that your allegations are clear. For example, you might receive a bullying complaint from an employee. It's not going to be sufficient to call in the respondent and say, look, there's been allegations of bullying, what do you have to say for yourself? You're really going to want to be able to show specific instances. So what form did that bullying take? Were there specific incidents? If so, what days, times, who were there? Were there any witnesses? What exactly was the nature of it?
And I think, Reece, that's where sometimes we see a lot of difficulties with investigation reports. The allegation is generic.
Yes.
It is vague, and it might not have specific examples. And that's why when we talk about homework, you need to have gone to the complainant. And this is very difficult. You need to go to the complainant and say, it's not just enough that Reece was rude to me. When? If you can't tell me the exact date, roughly what month? How many times? Where? All of those things, so that the respondent has a fair opportunity to respond. And one of the things I encourage investigators to think about in this context is you can have a generic overarching accusation, such as, Reece, you engaged in hostile behaviour or rude or aggressive behaviour towards Lewis, but you need to say, in a particular time period, but you need to say specifically, or by way of example, it is alleged that, and then bullet point, bullet point, bullet point, bullet point. You have the examples there.
That's right. And the key, I guess, is to make sure you've got as much detail as possible. And it may be that you receive a complaint, and as you said, you need to go back and speak again with that complainant and ask some further questions and say, look, we really need to be clear exactly what it is that's alleged to have happened here. And it's all about giving the respondent a fair chance to respond to those allegations.
So does that mean the respondent should get the transcripts and the witness statements, Reece?
Not necessarily.
I mean, you've just said lots of specifics.
Look, it's about putting some fine allegations together with very clear points and making sure that they're something that can be addressed, something that can be responded to, and providing those to the respondent. There's no entitlement to a transcript or a copy of the complaint itself, as long as they're given an opportunity to respond.
Oh no! Well, the reason I drew the breath is that I agree entirely that the ordinary rule, I think, is what's the focus needs to be. What does the respondent need to have a fair opportunity to respond? It may be in some circumstances that they might need to know a complainant identity, or they might need exact details of a particular narrative of what they've alleged to have said or whatever. And it might be they need certain accounts or identities to fairly respond, but that would not generally be the rule. That would be the exception, I would say.
That's right. And look, it comes back, I guess, as well to the question that we do get asked quite a bit, which is, what if the person doesn't want to participate? What if someone doesn't want their complaint to be made public? What if they want to remain anonymous? And that's obviously one of those situations you need to deal with at the outset. And I think part of that is making expectations clear.
Yeah, and I think we will come to this a little bit later on, but now that it's come up, I think the issue about someone not necessarily want to participate or not necessarily want to proceed. From an organisational perspective, you need to form a view as to whether or not there's a serious allegation that's been made or there's something allegedly improper. And if it is serious, you may need to conduct the exercise anyway. But as Reece said, once you've made that decision up front, it's then about giving the respondent as much detail as possible to enable them to respond.
That's right. All right, so we might talk about reports, which is another area where we do find that mistakes can be made. Obviously, if you're conducting an investigation, what you're going to want to end up with at the end is a report. Now, the reason you're going to put a report together is so that whoever's making the decision about the outcome, whatever it may be, a disciplinary procedure, you've got an independent person, not the investigator, making that decision, and they're going to want to rely on that report. That's really what you want them to be able to make their decision from. Because of that, it's important that when you're putting together the report, as an investigator, you show your workings. You make it very clear what's been done and what you've investigated and how you've reached the decisions you've reached. We say that the report should speak for itself, and what we mean by that is that somebody should be able to come along at some point in the future, pick up that report, and basically gain from it everything that they need to know about the report.
And sometimes this is where we see some reports somewhat deficient in the sense that they'll say there's an allegation, they'll say they've interviewed so-and-so and so-and-so, and then they'll have their finding. The point is you need to explain why that is your finding. And what explaining the reason for your finding is saying, well, why do you prefer one version of events over another? What are the bits of objective data or evidence or anecdotes or whatever it is that you've had regard to that have made you weigh up a contested version of events and landed at a particular angle? I suppose that's what brings us to burden of proof as well.
That's right. So it's important to know that in workplace investigations, the burden of proof is going to be balance of probabilities. So basically what that means is it more likely than not, based on the evidence that's available, that the allegation is true? We'll talk a little bit later about some of the areas around here, but essentially that's what you need to be aware of. It's a balance of probabilities. It's not a criminal case where it's got to be beyond all reasonable doubt. Simply more likely than not, did this happen or did it not?
Yes, and I saw Reece with his hands. It is a scale exercise.
It's
in the
balancing.
Sense that it's. I hate to use percentage, but it's like, is it 51% more likely or not that the answer is that occurred? And I think for many investigations where this will become difficult is when you have a classic he said, she said scenario where someone has alleged something, the other person's responded, you might not have a direct witness. What I always say to our clients about this, do not automatically conclude that every he said, she said scenario automatically is unsubstantiated, that, I can't make a finding. There will sometimes that will definitely be the case, but often there will also be scenarios where you can refer to other, reference points, patterns of conduct, things that have occurred, including someone raising the complaint contemporaneously. There might be a whole heap of circumstantial surrounding matters that lead you to ultimately form the view that a particular outcome is more likely than the other one, even though it's a he said, she said, and there's no direct witness. And that's what you've got to balance when you're applying this standard of proof.
And as you said before, you want to make sure that's in the report. Somebody should be able to look at it and make sure that whoever did the fact finding, whoever did the investigation, was aware of what that standard of proof was and how they basically came to their conclusion one way or the other.
All right, well, we're going to move on to some of the problems associated with conflating investigation processes and the difficulties that could arise. I think Reece is going to lead us off and no doubt I'll jump in.
Sure. Look, I think know your role, as we say here. It's very important that the investigator knows what they are there to do. Essentially, when you as a business decide to start an investigation, it's important that you essentially set out exactly what it is, what the allegations are, what needs to be investigated, So the terms of reference essentially are very clear for the investigator.
And this, particularly for the investigator themselves, this is really important. You need to know your scope so that you can, with confidence, say, I've done what I was asked to do. That doesn't mean that scope can't change. It might be that during a process, the things have come out that also require investigation. But as an investigator, that's not your call. You should go back to the person that briefed you and you should say, it's now come out that there's 3 or 4 other things that have been alleged. Would you like these included in my scope? But the beginning of any report should really set out the scope of what the investigator's been asked to do. And that provides the 4 corners or boundaries of their exercise and their report.
Yeah, that's right. I think it's important, as you said, to note that the scope can change. It may well be that after you've interviewed a respondent, they turn around and say, well, actually, this is what happened, and it turns out that there's other people that might be involved. And as you said, it's important to get instructions on that point and look at whether it needs to be changed, but that's not necessarily the job of the investigator.
So what is the job of the investigator? I mean, the investigator is obviously going to find facts. Should they be making the decision on disciplinary sanction?
They should not. It's always important that you have a separate, wherever possible, which is going to be in most cases, you have a separate decision maker from the investigator. There's a number of reasons for that, but it's about potential bias is a big one. So for example, if you're conducting the investigation, you might already, if you're going to be the decision maker, you may already have preconceived notions of what happened, and that can infect the investigation.
Yeah, and I think it's important for organisations to realise that the investigation, like we said at the beginning, is a fact-finding process. What should happen to a person is a different decision point, and particularly if a matter gets litigated, you want the fact finder, because that's often where there is contest, to again have a level of independence and separation from what is a much more subjective decision about what the consequence should be. The other thing that can come up as well is if you do have a documented report that has a proposed sanction in it, what happens then if the business doesn't follow that? You've got already an inherent inconsistency, right?
Yeah, we do see that from time to time. You'll get an investigation and the business will say, well, can you give some recommendations as to how we might respond? And I think there is a real problem with that because, as you say, it takes away the independence from the decision maker to a certain extent. If they're essentially being told what the best course of action is, it's not really impartial. Yeah,
and the temptation for someone internal might be, well, if I'm an investigator and I'm in HR, that your view might still be sought. I don't think that's necessarily hugely problematic as long as you keep it separate from the investigation process. It shouldn't be in the report. You can then be consulted about particular views. I think that's less problematic, but the report should stand on its own as the fact-finding exercise.
And we've got a point up here as well about having blind faith in the report. And I think one of the cases you're going to talk about later, Lewis, will go to that. But essentially, a decision maker as well shouldn't just rely entirely on the report itself. They do need to give consideration to the evidence and form their own view to some extent as well.
Yeah, we will show you an example of this, but in fact, I might just fast forward it now while we're talking about it. There was a decision involving a New South Wales government department. And we've got it up on the slide later on. It's Shakir in the Department of Family and Community Services. And what happened in that case was there was a great deal of contest in relation to whether or not Ms. Shakir had properly declared an illness. So there was a suggestion that some medical certificates that had been provided were false, effectively. And in reviewing the relevant information, it became apparent to the New South Wales Industrial Commission that was dealing with the matter that the allegations about the certificates being false just couldn't be made out on the timeline. But what had happened is because the investigator had said, no, I think this is these certificates are defective and do not represent her fitness at the relevant time, the organisation, the Department of Community Service, just took that on board as the misconduct and effectively relied upon it. And what the relevant member said at the time is, and it was in fact Commissioner Newell, he said, I observe here that persons having the delegation to, amongst other things, dismiss employees for misconduct cannot simply proceed on the basis of an investigator's findings without more. Dismissing an employee is a serious matter, and a person holding the delegation to dismiss must, in my view, form an independent view that the misconduct has occurred before considering disciplining an employee for misconduct. On any analysis, it is apparent that the allegations relating to the first two certificates, in this particular case, could not be made out. That ought to have been considered by the that ought to have been detected by the decision maker. The facts necessary to form that view were all available to her. And so what the Commissioner found is that there was really a defective or an element of clear failing on the part of the decision maker, because she, in this instance, had not properly turned her mind to the report, gone through, considered the findings. And you can't ever delegate that out. You're delegating the fact-finding process, but you have to actually have comfort with the outcome at the end of the day. Now, oddly enough, despite those two allegations, ultimately the respondent being vindicated in relation to those two, there was a third finding of dishonesty that did get up. So the employee, the outcome at the end of the day, the employee still lost the unfair dismissal claim, but it is a helpful and salient reminder of what decisions need to be doing as well. Right. We might move on to the interview process. There's a few really critical things for organisations or investigators to be conscious of when setting up the interview process. My first rule is, as much as possible, try and ensure consistency. If you're interviewing by phone, interview everyone by phone. If you're interviewing online or by Teams or whatever, Snapchat or whatever forum you're trying to use, do it consistently. Because it's possible that you may make findings about credibility, about a particular participant, based on body movements, based on tone, based on demeanour, and those types of things differ according to the medium. So obviously, I think for most people the starting point is if you can do in person, that's always best, but not necessarily critical. It may be that for a particular matter it's fine to do it by a video conference, or it might be okay to do it by phone. Just do it the same for everyone, unless there is an exception you have to make because of someone's availability or something like that. But you just need to be conscious that if all of a sudden you've interviewed 3 complainants and a witness personally, you've interviewed a respondent and said, oh, telephone will do, very difficult to then make findings of credit from different forums. It's probably slightly different if a respondent has asked that they only want to respond in writing. It may be that that's their preference, and in order to progress the investigation, you agree to that. But again, you're going to struggle to make findings of credibility based on things like how someone responds if you don't see them in person. The other things just to bear in mind, make sure you have the right amount of time available, because it's always preferable to knock the whole process over at once so that people don't go back, think about things, perhaps concoct their narrative a bit differently once they see where the investigation's going. Up front, very helpful to discuss recording and whether you're going to record or not. In the modern day, with apps available now, and I won't necessarily plug a particular brand, but we've got a couple of different apps and software we use, very cost efficient. You can record someone, the interview can be transcribed within 24 or 48 hours. It's done by AI, it's 90%, 95% accurate. It's pretty good as a basis to then go through the transcript and make any amendments you need. That makes the investigator's life a lot easier. You just need to make sure that if you're going to be doing that, again, you do it for everyone and you get their consent up front. And I think in relation to that, you need to think about how you're going to record these investigation interviews consistently across the board. Are we relying on transcripts? Are you instead preparing a witness statement for the employee? Are you just going to take notes? Each of them have advantages and disadvantages. A transcript transcribed by a word processing human being or AI has the advantage. Often it's the most detailed in the sense that it goes through in granular detail everything said. You can get errors, and that's why you do tend to need to go through the transcript, but it's probably the most comprehensive. Having said that, employees or witnesses sometimes can bottle themselves up a bit more if they feel like they're being recorded. Witness statements can be extremely helpful because you're going to go away and type up the whole narrative and then get the witness to endorse it. The difficulty with the witness statement is the time it takes. It's quite an administrative burden on the investigator to draft everything up, but it's certainly a very sound way to proceed should you wish. The least helpful is probably just taking your own notes. If you're going to do that, there's more prospect for people to challenge whether something was said or wasn't. It's difficult to take notes and conduct the interview at the same time. You're going to need someone else to take the notes. It's probably best for more informal type investigations. So they're the types of things to be thinking about in terms of the interview process. The last thing is, if the interview will be quite lengthy, if you think it's quite involved, just bear in mind that you do need to manage the breaks. We do see on occasion workers' compensation claims or just general complaints about investigation process if someone is put through some 4-hour interview and the investigator's forgotten to ask about breaks. You need to try and build that in. And probably the last one that we'll talk about is support persons. Reece, what's the deal with support persons? It's more tortured now than ever before with new legislative requirements.
It is. It's. I think one of the most common questions we get about investigations or disciplinary processes in general, and it's, do I need to allow the employer support person? Now, the answer is it depends. Generally speaking, there's no obligation, or previously at least, there was no obligation to allow a support person. However, if you're looking at, for example, an unfair dismissal jurisdiction, one of the things that the Fair Work Commission has to take into account is, was a person unreasonably denied a support person? So we would always, as a general rule, say it's best practice to allow them a support person if they want one.
Yeah. So you go.
So there's other reasons why that might be the case, particularly if the interview is going to be about a sensitive subject or distressing. It's going to make sense to allow them a support person just to make the whole thing run a lot smoother. One of the most common questions we get asked, though, is what can the support person do? I think there's a whole range of views on this from businesses that we speak to. I've had people say, well, the job of the support person is to sit there, but they're not allowed to open their mouth. They can pat their interviewee on the arm and they can, make sure they're okay, but it's not their job to speak and they're not an advocate. And you know what, we've spoken with people on the other end of the spectrum who say, look, it's fine for their support person to be a lawyer and it's fine for the interviewee not to actually say a word themselves and have their lawyer represent them as their support person. Now, I would say that both of those are incorrect. I think the reality is a support person is generally there to provide support. Now, it may well be that that support person can take notes, they can clarify, they can ask, they can step in if they can see that the interviewee is feeling unwell or distressed and say, look, can we take a break? That sort of thing. They aren't there to advocate. However, we've now got to address, I guess, the new rules about delegates' rights.
Yeah, so I kind of endorse everything Reece has said there. And one of the most important things about ensuring that an employee, particularly if they're responded to investigations, speaks themselves is whenever you get issues about honesty in the investigation process, if someone else has answered on their behalf, all of a sudden they can disavow the response or distance themselves from it later on if they didn't provide the reply themselves. And I've had countless unfair dismissal claims where someone's being dismissed for ultimately being dishonest, and there's things that have been said by the union rep in the meetings, and they'll say, well, I didn't say that, the union rep said that, and that's what might have been their view. And so you do need to ensure you're getting the respondent's account. But as you pointed out, Reece, we now have in every modern award delegates' rights provisions where someone who is covered by a modern award will have default provisions that do give a union delegate the right to represent their members. Those award provisions are also underpinned by national employment standards provisions that also confer a right of representation on unions. Now, representation is different to support.
It is. I guess the point is, though, that where previously you might have been able to get away with saying you can have a support person, but that's it, they're there to support you, they're not there to represent you. The reality is now that some employees are going to have a right to be represented in meetings and interviews and the like.
If they are a member of the union,
That's right.
and it's effectively their union delegate or union official that's acting
right.
in a representative capacity.
It's not a blanket rule, but there will be some employees, and so it's something that if an employee does ask for a representative to be there, it's something you're going to have to consider now and look at the scenario and say.
Yeah, and I think there's two interesting things that come out of that. One, which was a slight I just misspoke slightly, but actually sheds light on something, is these rights are for union delegates as opposed to union officials. So one of the questions will be who's coming in. Is it a delegate who has that right or an official who may not? But the second is, even if there's going to be a right of representation, rather than fight that, you might have to accept that as a reality. But what you need to be conscious of is if there are key matters that are being put to the employee and the representative is answering those matters, you may need to get some form of endorsement from the employee. Even if it's like, well, Joe Blogs, do you endorse your representative response, or you agree that's correct? Because if you're going to hold the employee to account or to a particular response, you need to ensure that they are endorsing what's being said. And so you're going to have to stop periodically to ensure that, so that they can't then distance themselves at a later date. So there's all of these kind of fractured issues that now come up with support people. I have to say, one of the other areas where things does go awry is I do sometimes come across some quite excited and officious HR representatives or managers that will say, oh, you're a support person, you're just here to provide support, you must not speak. It's a terrible way to commence an investigation process with someone. It automatically just kind of seizes up any rapport that might have existed. So just think about, do you need to say that up front? If you are, try and approach it from a relatively cordial and brief fashion. If the support person does ultimately misbehave and that they don't have a right of representation, you can always change the dynamic or explain to them or try and resist their behaviour during the course of it. The idea of coming on super overbearing at the beginning, I've seen many processes where that's kind of derailed the interview from the start. Probably one of the only other things that I wanted to talk about at this time about interviews is just the interview technique. The best types of interviews are ones that will blend open and closed questions. So an open question is one which doesn't presume a particular answer. It doesn't lead to a specific response. What happened next? Why did you do that? How do you know that? What was the next thing that happened, etc. They're questions that prompt an open response. They are very good to begin with because you don't want to start with a very targeted or closed narrative that then, by asking such specific targeted questions, you miss other context which is important. So if there was an incident on a particular day, I might ask Reece, on Wednesday the 30th of June, you came to work, what happened in the morning? Just nice and open, and Reece will start to think about the things that were relevant. And what happened next? Did you see anything else that you think is noteworthy on that day, or whatever it might be? Let him paint the story broadly, and then once you say, well, I now need to find out, yes, but were you in the kitchen with the candlestick, Reece, at this time? You can always ask that later on. And you can ask much more targeted, specific questions that you know you will eventually need an answer to later on in the interview. But if you start with the closed questions, you kind of cut through all the background context. It's hard to then pull it back because everyone's mind is now focused on a very specific small circle, whereas there might have been things in the broader circle or the broader narrative that you weren't aware of that might have been of assistance. So I think that's the most critical thing to think about when we're talking about interview techniques. Findings. I think we're back to you, Reece.
I think so. As we alluded to earlier, the burden of proof is important, and I'll expand on that a little bit. As we said, balance of probabilities is the relevant test. Was it more likely than not? But we do also need to talk about what's known as the Briginshaw standard.
So this is one of the most poorly understood and applied standards. So Reece going to clear all of it up right now.
Easy job. No. Look, what the Briginshaw standard basically says is that, yes, it's more likely than not, but the more serious the allegation is, the more evidence you're going to need to persuade you that it was more likely than not. Is that the best way of summing it up?
I think that's well explained, which is when there is a allegation of very serious misbehaviour, and the actual case in Briginshaw talked about fraud, theft, they were dealing with a misappropriation of fraud case in that scenario. But where you are alleging something that is serious misbehaviour, serious misconduct is a good example. The principle from the Briginshaw case is humans don't usually interact or don't usually engage in that type of behaviour. It's unusual for people to engage in theft or assault or fraud or whatever it is. And so if there is a factual allegation of that nature, you wouldn't lightly just assume it happened. You would want, and it talks about a cogent basis or cogent evidence to satisfy yourself on the balance of probabilities. Now, many people say, oh, it's a different burden of proof. It's not.
No.
It's the balance of probabilities, but as Reece, I think, quite well and quite appropriately explained, it's just the evidence you would need to satisfy yourself on the balance of probabilities is going to be more with a serious allegation than with a somewhat lighter allegation. And that's something that investigators need to take into account and call out, because that's the evidence tribunals apply and courts apply to very serious allegations.
I think on a practical basis as well, it's also worth bearing in mind that if you are looking at a very severe allegation that potentially is going to result in termination of employment, especially as you said for serious misconduct, it's probably more likely to be challenged by an employee. And on that basis, you're going to want to make sure that you're confident in your factual findings before you take that action.
Agree. Now, I think the other thing that we've got on the slide there, which we've already talked about a bit, is you don't just need to deal with witness accounts. You should be looking at other objective reference points or data points to see if you can substantiate something. And we've got a long list of examples there. That might help you land in a particular place. So just don't, I think as we said before, don't just kind of give up and unsubstantiate everything because I can't ever find anything because it's all so hard in this day and age. Strain to consider what might help you get to the relevant standard you need.
That's right. I think as well, it goes back to the he said, she said. Often it is difficult to make a call in that situation, but it's not just about what the individuals might have said. So for example, if you've got a complainant, a respondent, who's been called in an interview and the allegations being put to them, and their response is, oh, I don't think I did it. I probably didn't do it. And then finally they land on, yeah, no, I definitely didn't do it. You know, that speaks, I think, well to their credibility, and it's probably more likely than not that you're going to make a finding that they're not a reliable witness, and perhaps more likely than not.
Yeah, and you only pick that up by being there and hearing from them direct. So what are the kinds of findings we can make?
So, generally speaking, you're going to make one of two findings for each allegation. Now that's going to be either that the allegation is substantiated, and that is where, on the balance of probabilities, you have determined as the investigator that it is more probable than not that the conduct in that allegation occurred. So pretty obvious. Yes, there was an allegation, we've investigated. Based on all the evidence before us, we're satisfied that it took place. Now what you also might have is that the allegation is unsubstantiated, and there's a few different scenarios where that might come into play. Now the main two are that the allegation has been disproved. So when you look at the evidence, you can actually tell that it did not happen. There's no possible way that it could have happened, or I should clarify, on the balance of probabilities,
Yeah, that's right.
it didn't happen. And that might be because there was a misunderstanding, but often it's going to be without malice of the complainant. Might have been, like I said, a misunderstanding. They might have misinterpreted something. They might have taken certain behaviour in a manner that it wasn't intended, for example. The other one that often comes up is that where there's insufficient evidence. What it simply means is we do not have enough material before us, whether that's speaking to the witnesses, whether it's other evidence of the kind we spoke about previously. Just once it's all on the table, there just isn't enough there to make a finding one way or the other.
And I think that it's important in complainants and respondents understand that distinction, because it is very common to just say we don't have insufficient evidence. That, from the respondent's perspective, that doesn't mean they're exonerated.
Yep.
That just means we're not going to discipline you because we can't. We're not saying it didn't happen, we just can't prove it did. With the complainants, the same thing. You've got to try and remember that these complainants are very emotionally charged and aggrieved about whatever they think's happened to them. If you're not necessarily always saying this didn't happen, you're just saying we can't prove it. They need to understand that, because otherwise it can be a very disengaging process. Complainants can then go off the rails. We then end up with subsequent complaints, adverse action proceedings, resignations, constructive dismissal claims, a lot. It all just flows out if their complaints aren't necessarily substantiated. So you need to be clear that sometimes it's not always an exoneration, it's just saying we couldn't prove it. What you need to also be very clear with respondents about is that it is very rare to get to the level of confidence that an allegation's actually been contrived, deliberately vexatious or frivolous, such that the making of the allegation itself is misbehaviour. A lot of respondents, if they've been cleared, will often want that kind of vindication. It's very hard to give because, again, that's an extremely serious allegation. You would need to be very confident on the balance of probabilities that this has actually been entirely made up. And so that's all about managing the expectations of both complainant and respondent, because if you don't, then you're going to get subsequent claims. So what we might do now is just briefly take you through a couple of case examples that kind of bear some of these lessons out, and then we might just go to some of your questions as well. So the first case example that I was going to take you to is this Broken Hill operations decision from 2016. And the reason we've particularly chosen this is because there's a range of interesting things that unravelled in this particular case. So in the case, we had a scenario where a manager at a mine effectively was known for wearing, and I quote, a cap with an exceptionally large, and in brackets very much exaggerated, peak. So that is, it had an enormous peak on the hat for some reason. And a number of employees had noted this manager that liked to wear a hat with an exceptionally large peak. I've got no idea what this hat looked like.
I'd love to see a photo.
Yeah. So, and what then happened is that on Facebook, a number of employees of the mine had basically put on posts about a photo of the employee with the exceptionally large peak hat and had said things in the post that were somewhat disparaging of the employee. And to provide you with example, and I hope we're all adults on the webcast, the applicant in this case said things like, I've seen F-wits with bigger peaks on their hats. The next post he made said, next you'll be running the denim pants with reflective tape, which was apparently another feature of this manager who was very big on denim pants that they found quite hilarious. And in total, there were over 12 employees who either liked this post or made other contributions about this particular manager. So it's a form of bullying. I shouldn't be too kind of lighthearted about it, because clearly what we have in this scenario is a case of online bullying. The allegations were investigated, and in the course of the investigation, there was also a summary that was produced for management, which had some concerns about timekeeping discrepancies relevant to the applicant and concerns about attendance and whether there had been concerns about the applicant's timekeeping and record keeping about his attendance on site. They then went to discipline the persons involved, and there was actually different disciplinary action for different participants. The applicant was sacked. And what the Commission found when the unfair dismissal claim was brought is that at the time that the investigation was being considered, the discipline was being considered, there was another document that was in place that was being considered, which was this confidential report about the timekeeping and the gate entries and whether there was some concern. And the Commission found the view that that influenced the decision makers, but that it had never been put to the applicant. He just got the allegations about the bullying, but there was something else influencing their decision making he had never seen. And as a result, the relevant member, who was Commissioner Hampton, found, as he then was, he's now Deputy President, found that I have found significant procedural unfairness in the decision-making process. This injustice is likely to have made a difference to the fairness of the dismissal. The confidential report about the gate entries was very relevant to the investigation. Its contents were relied upon. He was not formally interviewed about these matters. It is probable this information, along with an earlier warning that was given to the applicant, which again he wasn't spoken to about as part of their sanction process, contributed to the view that the applicant, was part of a group of four whose behaviour was having a negative effect across other crews. So they've taken into account other stuff and they haven't put it to him. And that Reece spoke about this 40 minutes ago.
That's right.
Sorry, you were going to say something?
Yeah, that's right. What do you think should have happened, Lewis? If the investigator had found out that there was all this other material during the investigation?
He should have put it to the applicant.
Well, he should have sought instructions about whether he should put it to the applicant, I would say. But absolutely, it should have been raised. The respondent should have had an opportunity to...
And I think you're right in correcting me, because if they're not going to rely on it as part of the investigation process, you're right, then don't deal with it. But then the decision makers can't rely on it,
exactly right?
So, and that's where it all fell apart. So that's one example. We've already talked about Shakir and the Department of Family and Community Services, and the quote I read you earlier, we've got up on the slide for you there. The other case we're going to refer to is another example of where things can go awry when you don't follow the correct policies. In Romero and Fastard Shipping, there was effectively a disagreement or conflict between the captain of a ship and another worker on the ship, and the relationship had deteriorated such that Ms. Romero effectively wanted to leave the ship, was relieved from her duty, and she disembarked the ship mid-ship voyage, if I've got the naval terminology correct. And in the case, she then went and made a bullying complaint to her superiors about the conduct of the captain. When they went to investigate, they had a policy that set out that the employee, the complainant should be interviewed, allegations should be collated, then the respondent interviewed, etc. They didn't do that. They went and spoke to the captain, and the captain then basically unloaded on all these performance concerns about the applicant, even though she had gone to them with this bullying complaint. And the court, in this case was the federal court, found that there had been a rolling up of the concerns pertaining to Ms. Romero with the captain's own complaints about her performance, and that the allegations about her alleged incompetency effectively overtook the bullying process. The court said the two lines of inquiry should have been kept separate. They said it was appropriate for the company to pursue the captain's challenges about her competency, but in doing so, there were procedures in the EA which were to be followed. It was appropriate for the complaint to be pursued through its mechanism separately, and had that been done, then more likely they would have arrived at a correct outcome in terms of the bullying findings. And so they found a non-compliance with the contract, and they found that there were a variety of questions that arose about whether there'd been a repudiation of the contract and damages and all sorts of things like that. But it all went awry. And so those last two examples, you had effectively a significant compensation award was given to Mr. Remit in the mine case, and a series of orders were issued in relation to both costs and a repudiation of the contract by the federal court in this second case.
That's right. I think with this case here, the Romero case, I think it's also worth, not so much to do with the investigation, but it's a good reminder for employers about incorporating policies into your contract of employment, because that's where this fell down. The court said you didn't follow the policy and you had a contractual obligation to do so. And that's because the employee's contract didn't have a clause in there saying that the policies of the employer do not form part of the contract, and the policy itself didn't make that clear either. So it's always a good thing to check for employers. Make sure you're not binding yourself to certain policies and procedures by way of contract.
Yeah, well said. We're going to do a couple of quick examples because we do want to get some questions. He told me off the record. Your response, Reece?
He told me off the record? I mean, it's going to depend, right? If this is a case of do we investigate, I think it depends on the severity of it.
And if it is a serious matter, the fact that someone doesn't want to investigate it isn't necessarily the answer.
Exactly right. Employers have a wide range of obligations, for example, workplace health and safety obligations. If it's an off-the-record conversation about bullying, for example, you may still need to step in, even if the complainant doesn't necessarily want to go on the record.
So I might swing to some of our questions because we actually have a number of them. So I'm just going to start hitting you up, Reece. Can individuals outside the organisation make witness statements?
Absolutely. There may be a slight difference in process in the sense that as an employer, you generally have the right to compel your employees to participate in investigations if it's a reasonable lawful direction that they comply. Obviously, you're not necessarily going to be able to do the same to external parties, but certainly if there's relevant external parties, it might be former employees, it might be contractors, it might be just members of the public who witness something. If they can provide helpful information to get to the bottom of the allegations and provide relevant information for your fact finding, absolutely they can take part.
So a bit trickier. What can an employer do when an employee submits a workers' compensation claim as a result of a workplace investigation?
As a result of a workers' compensation?
As a result of a workplace investigation. That's right.
I mean, the reality is it happens. I think we're seeing more and more these days stress-related claims or psychosocial hazard-related claims come in. The reality is once you've received the claim, you've got to treat it as any other claim and follow the correct processes. I think the real question here is about making sure that your investigation process doesn't lead to any claims, and a few of the points we touched on earlier about support persons, making sure people aren't put through a grueling interview process and they're allowed breaks and so on, making sure that the allegations are clear, so it's everyone knows what's going on, and it's about as well dealing with expectations.
And I think that I agree. And the reality is there is an exemption in pretty much every state and territory. Workers' comp laws about reasonable management action taken in a reasonable manner does not give rise to a compensable claim. So the question is, did the way you conduct it, was that appropriate? If so, then complete the relevant forms with the insurer, outline what was done, and put forward your narrative, and that's how you would respond to that. Couple more questions that we've got. When CCTV is involved, should you reference the CCTV footage or use it by way of information to form the allegation details? That's an excellent question. I think when CCTV is involved, if you are trying to give the respondent a fair opportunity to respond, in many cases you may need to show the footage. You can explain what the footage shows, but it's going to depend on how critical this is. If you're trying to give someone a fair opportunity, if they're denying they did something, unless it is for some reason physically impossible, I would be giving them, you don't have to give them a USB or whatever, but I would be showing them the footage during the interview process, because that's probably what's required to give them a fair opportunity to respond.
You're going to want to make sure though that CCTV was obtained properly, and you've got to make sure that any relevant policies etc. in place and that you've complied with
So,
workplace
and
surveillance
what
laws.
you're really talking about there is in particular in New South Wales and ACT, the Workplace Surveillance Act.
That's right.
Or Workplace Privacy Act as it's referred to in the ACT. I think we've talked about this multiple times, but it keeps coming up. How do you navigate the challenge of a generic complaint when the complainant says they want action to be taken but isn't willing to be involved in the process? This is all about your WHS obligations. If your view is that something serious is alleged, the fact that you don't necessarily have a willing participant, you need to satisfy yourself as to whether it's happened or not. And you might still be able to ask questions of other employees or other witnesses. You at least need to go through the motions. If, on the other hand, it's not super serious, you might make a note of what's happened. You might say, well, we'll monitor this. But it depends how serious the allegation is. If it's an allegation of sexual harassment or misconduct, you can't just sit on it. If someone doesn't want to be involved, unfortunately, that's just not an acceptable outcome. You're going to have to say, well, we're still going to need to look into this. We didn't get to all the questions. We might come back to some people offline because we had a whole heap of questions, but I am conscious of the time. Couple of quick things for your benefit before we wrap up. We've got a wealth of resources available on our website should you wish. We've got some training advertised for positive duty, performance management and investigations in November. We've got access to some investigation and mediation services. So if you need both investigation or a mediator potentially after outcomes have been identified, able to offer those types of services through our accredited mediators. And we also have a series of toolkits available for sexual harassment, psychosocial hazards, etc. All available on the website should you wish. The next webcast will be in 6 to 8 weeks' time, and we've got a couple more to go before the end of the year. So please look out for the information. Other than that, Reece, thank you for joining me.
Thanks for having me.
And we'll be with you next time in a few weeks' time when we deliver on the next webcast. Thanks a lot, everyone, for joining us today.
Thank you.